So good morning, everyone, and thank you very, very much for joining us at this very early time. We are very happy to see you here, so you all earn a bonus or something. Thank you very much. We applaud for you. And welcome to the panel on the Law Enforcement Directive. As you probably know, because you are interested in it, and you are here at this early time, the directive on the protection of national persons regarding processing of personal data connected with criminal offences or the execution of criminal penalties and on the free movement of such data. So if the data is used by law enforcement authorities, this directive protects the persons concerned. It entered into force in 2016, and as it is a directive, it has to be or had to be transposed into national law until May 2018. So maybe I think it's important to mention that, in particular in the field of law enforcement, we don't only have criminals, we also have witnesses, victims, suspects, therefore we need maybe a better or a particular sensitive protection also of these data. And this is why I think we want to discuss this, these safeguards and everything in detail in this panel. And we also have to say, we, Eleni, Costa, and me, we also published a commentary, I think you see it on the slide, on the Law Enforcement Directive, which is, I think, the first commentary on this directive at all, to help practitioners, academics, and everyone who's interested in finding some, let's say, guidance on this directive, which also differs maybe the transposition a bit in the member states. So you will, we have a panel now with authors of this commentary, so specialists in this field who are very, very in the details of the Law Enforcement Directive and can give a lot of background information, a lot of new updates on case law, on Brexit, on everything which is connected to it. And I also like to thank Eleni for putting this together, and also the commentary. So it was a huge amount of work, I can say, and now we like to present some of it to you. And I immediately hand over to Herke Kranenburg, who is a member of the Commission's legal service and also a professor in Maastricht. Then we follow up with Uri Seifert of the EU Commission and postdoc at the VUB on the law enforcement itself, law LED itself, and some case law also on. Then Ruben Rookes, sorry for pronouncing it, partner at law at Timelex. So a practitioner who tells us a bit about the practical experiences on transparency issues, I think. Then Eleni Costa, the professor, of course, in Tilburg, will follow with the subject of rights and sensitive data on the Law Enforcement Directive. And finally, Nora and oh my God, I still forgot. Nielitson, Lloyds, director and senior lecturer at the Information Law and Policy Centre at the University of London, will follow with an UK view on it after Brexit, which is really an important and very topic I look forward to hear. So please, Herke, we start with you, and then we open the floor also.
Thank you very much. I guess we remain seated. Good morning, everybody. Indeed, it's quite impressive that you're here on the third day, early morning, after a party yesterday, so we are indeed super grateful. And congratulations, you too, of course, with editing this wonderful book, because I know that these commentaries are quite a monstrous job, and the nice thing is that once it's done, they're outdated, and you have to start thinking about the update again. So good luck with that. It was, by the way. So I was asked to say something very briefly about the case law of the Court of Justice on the Law Enforcement Directive. Of course, the big chunk of cases on data protection is all about the GDPR. We had this great influx in the last 3 years on in particular, preliminary rulings on the GDPR. And we see the results. I guess that during this conference, many of the cases have been mentioned or discussed, like Meta, etc. But there is this little brother, indeed, the Law Enforcement Directive, and there are more cases than one would think, perhaps. Yesterday I did some counting, and I came to a bit more than 15 cases in which the Law Enforcement Directive is mentioned. So when reading all those cases, I came to a few overarching reflections, and of course we can go into any detail later on if you like. So first of all, we must be grateful to the Bulgarian judges, or at least to one particular judge, I understood, because 5 cases came from Bulgarian court, which has now been dissolved, I understood, but still the questions have been taken over by other courts. And what is interesting is that that doesn't happen that often, but there are 2 cases. One is not strictly about Law Enforcement Directive, but coming from that same court, is that after the Court of Justice gave answers to the questions, the referring court asked to clarify the answers given by the court, which to a certain extent is not entirely justified, because sometimes there seems to be a sort of intentional misreading of the answers of the court. But then somebody assured me that one of the judges is apparently writing a PhD on a subject and wants to. That's perhaps false gossip. But then on substance, if you look at these cases, there are of course cases where the Law Enforcement Directive is just mentioned. And one would think that the data retention cases are, the famous string of data retention cases would be obviously also about the Law Enforcement Directive. That's not necessarily the case. That's all about the e-privacy directive, the possibility to have this retention obligation for law enforcement purposes, but it has nothing directly to do with the Law Enforcement Directive. That's only once you have collected or accessed the data that has been stored by the companies. Still, there are some data retention cases in which the Law Enforcement Directive is mentioned, like La Quadrature du Net, the first La Quadrature du Net, and also Privacy International. There's also a case on the red notice of Interpol, where there was a mention of the Law Enforcement Directive, a German case. But those were merely mentioning Law Enforcement Directive, basically. Then, if you look at several of the cases, you see that one of the big issues the court is dealing with is actually the relationship between the Law Enforcement Directive and the GDPR. And there, when reading it again, I saw something interesting caught my eye. Because if you look at so it's the Belgium case, if I'm not mistaken, on the EU PNR directive. So the question was whether the EU PNR directive is valid in light of the Charter. And there the court looked at because on the one hand you had PNR data, on the other hand you had API data. PNR was for law enforcement purposes, you could say. API was for border control, which is not law enforcement. So what the court did was look at the famous linking provision of the GDPR. So that's Article 2.2d. I don't know if you are much into this, but there it says that the GDPR will not apply to data processing by competent authorities for law enforcement purposes, to keep it simple. If you then look at the Law Enforcement Directive, you find the same notions, because that's the scope. This carve-out is actually the scope of application of the Law Enforcement Directive. Question is, of course, what is a competent authority? That has also been spelled out in the Law Enforcement Directive. But what is so interesting about this Belgian case, the EU PNR case, is that the court says, well, 2.2d, Article 2 of the GDPR is about the material scope of the GDPR. What is listed there, A, B, C, D, are exceptions to the scope. A says if it's outside the scope of union law, it doesn't fall under. It's household and activities also in there. But D is about law enforcement activities. And the court says these exceptions to the scope must be interpreted strictly. And that's quite fascinating, because in a way, for that particular one, and maybe another one as well, but for this particular one, why would it be justified to formulate the Law Enforcement Directive in a way as an exception, the scope of the Law Enforcement Directive as an exception which should be interpreted strictly to the GDPR? I hope you follow me. So there is no hierarchy between the two. They are both instruments of secondary union law, so in principle this statement is a bit awkward. And then, if you look at it, so as said, the court said that this API data collection, that was GDPR. PNR collection was Law Enforcement Directive. It looked at the PIUs, which are created under the EU PNR directive, and said these are law enforcement authorities. So they qualify as competent authorities within the meaning of the Law Enforcement Directive. So Law Enforcement Directive apply to that part. Then leap forward, the Hadopi case. That's the second La Quadrature du Net case, which was issued on the 30th of April, so very recent. I don't know if you saw it, but that's the case which has been advocated as where the court is nuancing, revising, or whatever, doing something with the data retention case law. Well, apart from that part, which is interesting in itself, of course, there's also a last part which is about the Law Enforcement Directive. And there, the court says something about whether the entity which has been created for this system falls within the scope of the Law Enforcement Directive. Very quickly, this Hadopi system is about the fight against the illegal sharing of intellectual property rights infringing materials on peer-to-peer networks. So illegally sharing of videos. These IP addresses of people that do it are collected by designated authorities, you could say, or organizations. They give the data to an independent public authority, Hadopi, which is now called ACROM, if I'm not mistaken. And that ACROM then contacts the internet service provider to see who is behind the IP address. And then, if they know, they send a recommendation to the person behind the IP address. And if the person continues or does again an infringement after 6 months, a second recommendation is sent. And if then a year later the person is still involved in it, then it might be considered as gross negligence, if I'm not mistaken, or even counterfeiting. And then the dossier may be sent to the public prosecutor. So we have these 3 steps. And the court in Hadopi says that because in the end this might lead to a criminal prosecution, what Hadopi as a governmental body is doing falls within the scope of the Law Enforcement Directive. And that goes very far because the whole situation can stop already at the recommendation stage. In the majority of cases, it will not lead to a referral to the public prosecutor. And then if we go back to the EU PNR case, then it's quite remarkable with this strict interpretation that the court gives such a wide interpretation actually to the scope of the Law Enforcement Directive. Then, last point, because we had to be brief, then there are cases where you could say the real interpretation cases on the Law Enforcement Directive, and I counted 4 cases, and they are interesting, depending, of course, on what angle you take and what activities you're doing in the law enforcement area, but some of these are the Bulgarian ones, which are about the collection of DNA data. If somebody is suspected of an intentional crime, immediately DNA data is taken and it's put in a database. And there were several issues with that, and that's also one of those cases which had led to a second referral of the referring court. But one was the lack of proper judicial control before the DNA data was given if somebody didn't want to cooperate. Another one is that the DNA data was kept lifelong in the database, in any case. And the court in both cases said, well, for the first, you need to have, at some stage, full judicial control of the collection of this data and the retention of that DNA data. And second, it's excessive to have lifelong storage of all DNA data of any person who has been suspected of having committed an intentional crime. And then there's, I like that case a lot, it's a Belgium case, which is about Article 17. Article 17 is really a special feature of the Law Enforcement Directive. That's about that if your rights are restricted as a data subject, you can execute your rights via the Data Protection Authority. And in Belgium, the question, actually all requests are referred to the Data Protection Authority or are performed by the Data Protection Authority. So there's no, as an individual, you don't even know necessarily the identity of the real controller of the data in the police sector. And the question was, if the Data Protection Authority is answering you after it has done what it should done, and it says only, because that's Article 70 says that you must be informed that at least that the investigations have been done and it has been concluded satisfactorily, whether that's a decision which is challengeable by the data subject. Because in a way it sounds a bit weird because they are acting on your behalf in a certain way. Can you then still go to court if they conclude their own investigation? And the answer the court gave was yes, Because you can imagine if you don't, if that avenue would not be available and you don't know the identity of the controller, then you are out of any judicial remedy, which is, by the way, the article I commented in the commentary. Last remark, please note, in this Belgium case, C333/22, there was actually also a claim that the Law Enforcement Directive would be contrary to the Charter, Article 47 on this point, and the court concluded that it wasn't. So it actually survived an attack which was perhaps not that much noticed.
Thank you very much, Hek, for this overview. Now I think we follow up with you, Rise, I thought. Thank you.
Thank you, Franziska, and thank you, Eleni, and to Tilt, obviously, for inviting me. I'm here in my personal capacity, so whatever I say does not represent European Commission views. To begin with, I would like to pick the ball of Herke, so focus a little bit more on this, let's call it Bulgarian CJEU case law about the LED, in order to ground my argument in those cases and show you how I think that repurposing of personal data under the LED should be understood and applied and eventually enforced as well. So the first case was, out of the two that I would like to focus on, was 180/21, let's call it Inspector. That was the first time that the purpose limitation principle as defined in the LED appeared before the CJEU, and I think it's defined differently than the emanation of the principle is different in the LED than the one in the GDPR. In that judgment, the court found that at least each law enforcement activity mentioned in Article 1, Paragraph 1 of the LED is a specific and distinct purpose of processing. So those are prevention of criminal offenses, detection of criminal offenses, prosecution of criminal offenses, execution of criminal penalties, prevention of threats to public security, and safeguarding against threats to public security. They're all specific and distinct. I don't think that they are very specific. I think this is still quite vague, but it's a first step that will be later on developed in the judgment 205/21. And more importantly, in this judgment, as regards compatible use of data, the court found that the change of purpose triggers the applicability of Article 4, Paragraph 2 LED, which is about repurposing of personal data under the LED, even within the same criminal proceedings. So, for example, when prevention or detection of criminal offenses is followed by prosecution of criminal offenses. And that, I think, is the very important part of the judgment. So the court found that the data necessary for investigating a criminal offense may not be necessary for prosecuting a criminal offense. The court also found that different phases of criminal proceedings might result in different intensity of interference with the right of personal data protection. And that is also very important because this Article 4, Paragraph 2 of the LED that I mentioned in itself contains a necessity and proportionality test. So it allows repurposing of personal data within the realm of the LED if necessary and proportionate. And if the level of interference changes, that also influences the weight you give to the security objectives pursued by certain law enforcement measures or the right to personal data protection. When you put them when you do the proportionality in the strict sense test, which is actually the balancing test. So this Article 4, Paragraph 2 of the LED that I will often refer to is triggered when personal data move from one law enforcement activity, like detection or investigation of criminal offense, to another, prosecution of a criminal offense, also regardless of whether personal data is changing hands. So whether they are being sent from, let's say, police to a prosecutor office, or even if they remain under the same controllership. So here already the court made, I think, quite clear that Article 4, Paragraph 2 of the LED is a funnel. It plays a funnel function for data that moves through different stages of criminal proceedings. And the second judgment, that 205/21, let's call it Ministerstvo na vatrašnite raboti. So that judgment, I'm sure you will all remember this. that judgment strengthens the part that was weak in the first judgment, the purpose specification in the LED. Already the Advocate General argued in that case that if you rely merely on one of those purposes that were enumerated in Article 1, Paragraph 1 of the LED, you cannot meet the requirements of the purpose specification block of the purpose limitation principle from Article 4, Paragraph 1, letter B of the LED. So the Advocate General expects national laws that serve as basis, as legal basis for processing by law enforcement authorities to specify purposes of processing in a clear and precise manner. So he insisted it's not enough to state that the collected personal data will be used for criminal proceedings or for purposes of fighting crime. He also said it's not enough to cumulate purposes that are enumerated in Article 1, Paragraph 1 of the LED without an explanation of reasons that a certain purpose is justifying certain processing operation. The court did not really endorse all these arguments put forward by the Advocate General, but it did acknowledge in that particular case was about biometric and genetic data that you can collect biometric and genetic data during criminal investigations, but that does not reflect any specific necessity for the purposes of the criminal procedure in progress. So there the court even created this notion of specific necessity, probably because it was about sensitive data, but I think it strengthens maybe the weaker part of the judgment, the first judgment. So if you read together these judgments, I think they're actually supportive of the old argument made by the European Commission back in 2018 that all those 6 different instances that are defined under Article 1, Paragraph 1 of the LED, which is about the scope of the LED, are objectives, and they are defined in a general manner, while purposes have to be specifically defined, so that you demonstrate what is behind each processing operation and why certain processing operation is being carried out. And when it comes to the change of purpose in the LED, a lot of ink has been already spilled about further processing and compatible or incompatible tests under Article 6, Paragraph 4 of the GDPR. But little is known about these tests that I already mentioned are under Article 4, Paragraph 2 of the LED and how different they are. I call the GDPR test further processing, and what LED is interested in, I call it subsequent processing. And some authors have criticized this distinction as merely semantics, but I think, obviously, I disagree because, and I will say why, because further processing and this compatibility test under Article 6, Paragraph 4 GDPR is not absolute. There is possible to do incompatible further processing as well under the first subparagraph of Article 6, Paragraph 4 GDPR if that is allowed by law. But there is no necessity in proportionality test like the one that exists in Article 4, Paragraph 2 of the LED. So that's the main difference. And if I use an example of law enforcement accessing data that is held by commercial service providers, I would say that transition of data from GDPR to the LED is 2 sides of a coin. So on the GDPR, the commercial operator will carry out the disclosure of data to law enforcement authorities under the GDPR rules on further processing, while the access to the data by law enforcement authorities is tantamount to data collection. So that is actually the moment that triggers the application of the LED, and the processing of personal data under the new legal regime, in this case the LED, should be understood in the same way as initial data collection. And that triggers all the obligation of data controllers that the concept of further post-processing might not include, such as, for example, right to obligation to inform the data subject. And then after this initial processing, there could be further subsequent processing under the different test, which is the one of Article 4, Paragraph 2 LED. Also, another point in this context that some authors criticize is presumption of compatibility of purposes. that within the scope of the LED. This is something that doesn't exist in the GDPR. But here, again, the crucial difference between further processing and subsequent processing comes to the forefront, because LED is not really interested in compatibility or lack of compatibility of purposes. If the data controller wants to change the purpose, it's a different test, so the new purpose needs to be authorized by law, but also subject to the necessity and proportionality test. And that is what it actually acts as a funnel and ensures that less and less personal data are processed after each step of repurposing of personal data under the LED. So there is a certain amount of data that is being accessed, and even less is then processed for detection or prevention purposes, and even less for investigation purposes, and even less for prosecution purposes, and so on. So in conclusion, when LED allows compatible, necessary, and proportionate repurposing of personal data within the law enforcement realm and between the actors in the criminal justice systems, these are not three empty words. They have to be interpreted in a meaningful fashion, so compatible, necessary, and proportionate. So I think the LED sets, and that's my concluding remark, sets already important limitations on the use of data from a variety of sources, as well as on the sharing and repurposing of data within the law enforcement realm. And these limitations are very important in the context, obviously, of big data and AI used by law enforcement, no matter what other pieces of legislation may or may not be saying on this matter.
Thank you, Juraj. Thank you also both for timekeeping. It's important with 5 panelists. Thank you for this overview. I think now we turn to a more practical side with Ruben.
Sure, thank you. Hi, good morning, everyone. Great to see you all here, quite a lot of people. My take on the subject is a bit more practical. So if you'll allow me, I'll give you a bit of background as to where I'm coming from. And then I want to talk to you about the issues that you have with the notion of transparency under the LED in practice. So the background to my little talk here is, or my intervention, is that I'm involved in a European project, a very practical project, I must say, that is focused on automating the way in which law enforcement agencies across Europe deal with so-called NECMEC reports. Probably not all of you know what those are, so I'll explain briefly. In the area of the fight against child sexual abuse online, the operators, the big tech operators on US soil are required to report the indications of child sexual abuse online to an NGO in the US called NECMEC. And what NECMEC does is they compile all these reports, and then through a whole chain, which I won't go into details now, they will send it to the law enforcement agencies that are most equipped to deal with the evidence found, right, or the evidence reported by the tech sector. Now you can imagine that for years, the amount of material that is being reported goes up massively. And so you end up with an issue where law enforcement does not have the resources to effectively deal with everything that is being reported. And so the Aviator project is meant to develop, and actually it already exists, it's a software tool that will be installed at law enforcement premises locally, and it will pull in these NECMEC reports, and then will automatically assess to see whether or not we have infringing material or not. Because as you can imagine, people report stuff, the tech sector reports stuff, but not everything that they report is necessarily illegal everywhere. And so what the tool does is it helps law enforcement to classify and prioritize. Now, in order to do it better, the tool also uses open source intelligence capabilities, automated open source intelligence capabilities, in order to prioritize. Example is, for instance, if you see in a NECMEC report that an alleged perpetrator is active as a school teacher, there is probably a heightened risk that he has direct access to a child. Hence, we would prioritize the report. That's the idea, right? So that's where I'm coming from. We have this tool with very effective capabilities. It works very well. But it has to function under the umbrella of the Law Enforcement Directive. And we, as legal partner in the project, were asked to assess what the consequences would be for law enforcement agencies to use this tool, specifically under Belgian and Dutch law, but of course it has to work across Europe, so we looked at the LED as well. And this is where it becomes interesting. I don't know how well versed you are with the LED, but probably all of you know the GDPR very well. Under the GDPR, we have very clear transparency obligations, right? Transparency is one of the core obligations that you have to comply with, Article 5. The LED is somewhat less clear on the matter. It's not that there are no transparency obligations, but if you look at, for instance, Article 4, which is about the core obligations that we have in Article 5 under the GDPR, a similar provision you have in Article 4 of the LED, transparency there is not mentioned as such. It is mentioned in Recital 26, and it is repeated again in Article 13 as being an essential obligation for the controller under the LED to be transparent. But this is where it gets a little bit difficult, because again, we looked at this from a practical perspective. I'm a law enforcement agent in Belgium. I want to use this tool. I need to look at national law first and foremost, because the LED has to be transposed. And then you are confronted with the following thing that law enforcement agencies currently are doing in Netherlands and Belgium, but they're doing it across Europe in the same way. If you want to inform people as law enforcement, the first thing that most law enforcement agencies right now do is they will put up a privacy notice on their website, like many companies do under the GDPR, right? We will put on a privacy notice on our website and we'll try to be proactively transparent. And we try to do that to comply with Article 13 of the LED. But the problem in this domain is where, if you look at the GDPR and you want to be transparent as a company, the first question will be, who's the controller? It's very easy. It's the company. I know what my company's name is. I know what the company details are. It's very easy to do. But if you try to do the same thing under the LED, it becomes complicated, because in national law, it will be the national legislator that decides who will be a controller for a particular police activity. And the way they deal with this is different across the member states. Even the police not always know who the controller would be for their processing activity. So that's where the first challenge comes in. The second challenge would be the purpose specification problem. It's already been touched upon by the previous speaker. Many legislators, national legislators, interpret the purpose specification principle in a very simplistic way. We simply look at Article 1.1 of the LED. The purposes are all mentioned there, so we will reiterate them in national law, and then the police will reiterate them in their privacy statements online. We've already heard that might not be specific enough, and I agree that will not be specific enough. You don't know what they intend to do, but that's the way they do it in practice right now. Another problem, the legal basis for processing. This is a very, very challenging thing in the law enforcement realm. The LED states that the legal basis for processing will be the task you perform in the public interest as law enforcement agency, and so that task needs to be defined somewhere. How do they do that specifically in the area that I'm discussing right now? In Belgium and the Netherlands, they simply state that the police has the task to investigate crime, detect crime, etc. So they sort of reiterate what Article 1.1 says, and they provide a very generic description of what the police task would be. So again, you end up with lack of specificity, but also it's an interplay in many countries between a lot of different laws, because countries will have transposed the LED in one act, but they have other acts that govern the competences of law enforcement agencies. So you get that weird intertwining of different laws, where it's very difficult to make distinction between what purposes are, what tasks are, and what objectives are. It's a complicated patchwork, right? And now you have to tackle the transparency obligation, which Article 13 still prescribes, in a way that, whilst complying with Article 13, you do not want to inform perpetrators, of course, of what you as law enforcement agency are doing specifically. In my case, in order for the OSINT technology to work, If we say we're scanning social media to look for your profession, obviously the first thing that everybody will do who's active in the criminal part of this sphere, they will delete their professional designation, obviously, so the whole thing would fall through. So that's not going to work. Does that mean that we're going to ignore it all and we will simply revert back to the privacy statement that the National Police has on their website, which doesn't say a damn thing? No, that's not what we're going to do. But we're going to treat transparency from two different angles. One is the more indirect approach to transparency, where you say, we will do the DPIAs we're required to do. We will inform the national authority proactively of what we're going to do. We will ensure that they know what we're doing. So if data subject requests come in, the authority already knows what they have to look for. There will be no secrecy whatsoever towards the enforcer. That's one, but that's of course indirect. We have to take the direct approach as well, I believe. I mean, Article 13 is what it is. That means that in this case, we would like to petition the national authority to come up with guidelines as to how law enforcement can deal with these type of technologies, not in specifically to that technology, but in general, so that the public knows what is going on. So transparency through the enforcer again. And then secondly, through ourselves, as law enforcement agencies, through public outreach programs, where we at least inform the public of what we're doing, what department within the police is doing what, again, without going into too much detail, but providing the public with sufficient knowledge that they know what's going on, that if they want to exercise their rights, that they can do so, and that they know to ask the authority the right questions. So that's the way we're trying to do this, right? A two-pronged approach. Indirect, through the enforcer, direct, through public outreach. And we hope that in this way, we sort of reconcile at least the general principles that the LED imposes upon us. And that's what I wanted to say. I hope that I remained within my time.
Perfect. 10:15. Thank you very much. Thank you. Very interesting, actually.
Thank you.
Insights. Yes, please, Eileen, go.
Thank you. So a lot of interesting stuff has already been discussed, so it's, I should have chosen the first presentation. So there are a lot of interesting things that I would like to raise, but I will mainly focus on two, and then there is quite a bit that I would like to leave for the discussion so that we have sufficient time to engage with the audience. First of all, I like very much the fact that everyone has gone very deep into details, and I hope you find this useful. So we already heard about sensitive data in the LED. So this is Article 10 of the Law Enforcement Directive versus Article 9 of the GDPR. The Court of Justice discussed in a couple of cases Article 10 of the LED, and I would like to go back to the fundamentals of processing personal data and highlight some main differences between Article 9 of the GDPR and Article 10 of the LED in order to then try to discuss during the engagement with the audience whether these differences make sense. So first of all, something that I don't think has been highlighted because the focus, of course, of the court was different, is that the wording in Article 10 of the Law Enforcement Directive on the processing of sensitive data is fundamentally different compared to that of Article 9. So in essence, Article 10 introduces, Article 9 of the GDPR introduces a general prohibition for processing of personal data in its first paragraph, and then it enlists a number of grounds based on which the processing of sensitive data can be allowed. This is not the case in the LED. Although the categories of data that are considered sensitive data under Article 10 of the LED remain the same, Article 10, and I quote, says that processing of sensitive data shall be allowed, so there is no mention of prohibition, so actually it is allowed by, according to Article 10, under two conditions, when it is strictly necessary, so we'll go back to the necessity test, you heard a lot about it, and subject to appropriate safeguards for the rights and freedoms of data subjects. So this is fundamental, and I would like to draw your attention to this. So actually, under the LED, the processing of sensitive data is allowed under strict conditions, yes, but we move away from the prohibition that was introduced in the GDPR, which is kind of, I would say, interesting to discuss. And the second point is that the list of exceptions that we have in Article 9 of the GDPR, so actually the list of grounds based on which the processing of sensitive data can exceptionally be allowed, is much more extensive in the GDPR. That makes sense if we think of what the LED is doing and what are the data controllers according to the LED. We already heard some things about the competent authorities. But here I would like to remind you that there are 3 grounds mentioned in the LED, only 3 grounds. The first one is where it is authorized by union or member state law. Clear, it's usually where we see the police relying on for processing of data in general, of sensitive data more particular, and this is where the Court of Justice is also trying to find a basis to justify processing of sensitive data by police authorities. The second one is to protect the vital interests of the data subject or of another natural person. It's rarely used, I dare say. The third one is where such processing relates to data which are manifestly made public by the data subject. And the manifestly made public ground is something that we see also in Article 9 of the GDPR. It is quite interesting. What is manifestly made public? What is the intention of the data subject? But I will not go deeper in this. We can discuss afterwards, because this is a topic that my brilliant PhD student hiding at the very back, Taner Kuru, is working on. So I will refer you to his work on this. But I think there is a lot to be said on how this is, how this should be interpreted, and whether we can actually rely on this ground, especially in view of the challenges relating to sensitive data. And I found it interesting already that the Court of Justice discussed Article 10, discussed processing of sensitive data. However, they didn't take the opportunity, if you ask me, to go deep into outlining or giving us some more guidance on how to apply Article 10, which is quite problematic. The second, and I'll try to be very brief so that we have enough time for discussion, is I would like to draw your attention to Article 11 of the LED, which is on automated individual decision-making. We have a similar provision in the GDPR, Article 22, on automated individual decision-making, including profiling. And there, again, I would like to draw your attention to the big difference in the wording used. So Article 22 of the GDPR establishes a right for the data subject not to be subject to a decision that is based solely on automated processing. So when we discuss it with my students, I always tell them, well, what is a right not to be subject? In reality, it is an obligation for the data controller that they should not carry out, that they should not come to decisions that are based solely on automated processing. However, the wording was very carefully used. And Article 22 is part of the rights of the data subject. Is it only semantics? That's something that I would like to have the opportunity to discuss with you. While in the LED, we see a completely different wording. Article 11 of the LED establishes an obligation for the member states to provide for a decision based solely on automated processing, including profiling and some extra conditions similar to the GDPR, to be prohibited. So here, it's not a right of the data subject, which can be a suspect, a victim, a convicted person. But in this context, there is a clear obligation to prohibit such decisions being taken unless authorized by union or member state law to which the controller is subject and which provides appropriate safeguards for the rights and freedoms of data subject. So does this actually mean that the police falls under different requirements for using systems that lead to decision-making based on solely on automated processing? I was not on the panel yesterday because I arrived late on Europol, but I heard that Europol said that they can actually use AI broadly because they need it. And don't forget that Europol does not fall under the AI. We can discuss it. And the thing is, we see in the AI Act that the legislator has a lot of very strict provisions relating to law enforcement, of course with a lot of exceptions. So if we compare the proposal of the European Commission on prohibited practices, for example, compared to the final text that we got, we see quite a bit of differences. But how should we read Article 11 of the LED compared to Article 22 of the GDPR? How do we understand this difference between a right and a prohibition? So these are 2 points that I would like to focus on for the moment, and yeah, I hope we can have some time for discussion.
Thank you, Eleni. A very important topic as well to be discussed. So, Nora, you have the final word, but we are looking forward to this very interesting Brexit discussion and some new insights into the politics I heard.
Yes, thank you very much, Francesca and Eleni. It's wonderful to be with you here this morning, and also wonderful to be part of this fantastic commentary. If you do not have a copy already, please do so. It's quite fantastic and covers in so much detail a lot of areas of the Law Enforcement Directive that really hasn't been subjected to more detailed guidance in other quarters. So it's a very valuable source on the Law Enforcement Directive. So as Francesca just mentioned, I will be focusing on the implications of Brexit in terms of the Law Enforcement Directive. But I have a very quick disqualifier to share with you all right now in the form of some breaking news that happened this week. It's, I think, something that you never quite expect for your presentation at CPDP to be usurped by the UK Prime Minister, but here we are. And we have a national election that's been called in about 40 days' time. Why am I telling you this, aside from my shock and awe at the news on Wednesday evening? Is because this means that any bills before Parliament would have to be fast-tracked within the space of 1 working week, because Parliament is going to be dissolved in the next few days. And we have a bank holiday on Monday as well. So it's important to note that the Data Protection and Digital Information Bill, the points of which I'll discuss now, is a bill that has actually been in gestation for some time since Brexit occurred. This is the second bill for which we had reforms to not just the GDPR in the UK, but also the Law Enforcement Directive. So I would very strongly note that even if this bill falls, that the reforms being proposed here to amend law enforcement use of data processing in the UK may very well manifest itself with the next government and their new proposal of how the data protection law in the UK is going to be amended. So I will go forward and discuss the current provisions in the Data Protection and Digital Information Bill. One of the key reforms I'd like to mention first is the provision for logging of records under the Law Enforcement Directive, and also data protection impact assessments under Articles 25 and 27. Now, the current clauses in this fated bill involve the watering down of these two requirements, particularly the rights-based approach to the linked accountability provided by both of these requirements under the Law Enforcement Directive. Clause 19 of the bill removes the requirement for law enforcement authorities to record the justifications, the reasons why an automated decision was used, and why information from that system was disclosed or shared. So of all of the factors that should be recorded as part of logging and data protection impact assessments, it is quite significant that the justification would be removed. And why is this so important? Well, that's because information and records on the use of data-driven systems, such as the one that Ruben just mentioned earlier on, very powerful, very important systems fulfilling needs for law enforcement, those records are crucial for the oversight and monitoring of those systems to make sure that we know they're being complied with lawfully, and also, as mentioned earlier on, in compliance with the necessity and proportionality principles that Uri mentioned. An amendment like this is also problematic in terms of the UK's obligations as a contracting member state of the ECHR. It's contrary to the Grand Chamber judgment of Zakharov versus Russia, delivered in 2015, where the court stressed that the obligation on public authorities to keep records of interceptions or other forms of surveillance is particularly important to ensure a supervisory body has access to the activities that law enforcement are undertaking to fulfill their tasks and duties. Clause 20 of the bill would replace data protection impact assessments. So we would no longer have data protection impact assessments, we would have assessments of high risk. So why is this significant? Well, it would no longer require law enforcement authorities to state what safeguards, security measures, or mechanisms to ensure the protection of personal data and other affected rights have been undertaken if a particular automated system, for instance, is implemented. And it's quite significant to note the history of this particular reform, the scaling back of data protection impact assessments. We had a very significant judgment, the world's first judgment on police use of live facial recognition, South Wales Police versus Bridges in 2020. There were two judgments, one case. In the Court of Appeal judgment in 2020, one of the key grounds for which the South Wales Police use of a particular live facial recognition system was deemed unlawful was the fact that the data protection impact assessment was found to be deficient. Why was it found to be deficient? Because it failed to properly assess the risks to the rights and freedoms to the affected data subjects in Wales, and it failed to address the measures envisaged to mitigate those risks, to safeguard against them. And this was specifically with regard to the wide discretion that the South Wales Police had available to them in terms of who would be targeted on watch lists by live facial recognition systems and where those systems would be deployed. So this is a very significant requirement under the Data Protection Impact Assessment that would just be carved out. Secondly, we have the encroachment on the independence of our data protection supervisory authority. Now, this is quite a significant reform that also has major implications as well for the GDPR, not just the Law Enforcement Directive, Part 3 of our existing Data Protection Act 2018. And I'm sure many of you know that the complete independence of data protection supervisory authorities is enshrined both in the GDPR and the Law Enforcement Directive under the EU Charter of Fundamental Rights under Article 8, and it is reiterated very robustly by the Court of Justice in many of its data protection judgments. It is considered to be an essential component of Article 8, and it's specifically referenced to in Article 42 of the Law Enforcement Directive. So Clause 120B would also introduce new and unrelated duties to the Information Commissioner's Office, our Data Protection Authority, which encroaches upon his primary objective, which is the protection of personal data of individuals within the UK. Further duties that he would be required to consider would be the desirability of promoting innovation, the desirability of promoting competition, why not? And also, very interestingly, the importance of the prevention and investigation, detection and prosecution of criminal offences, which for me has always been the remit of law enforcement authorities, and then also the need to safeguard public security and national security. So these are duties that very much step outside of the parameters of how the tasks and duties of data protection authorities are defined under the Law Enforcement Directive. That is beyond question. Why would it be happening in this particular context? Well, another element of the Data Protection and Digital Information Bill is that there's a proposed abolition of another oversight authority we have, which is the Biometrics and Surveillance Camera Commissioner. Now, the Biometrics and Surveillance Camera Commissioner is a form of internal oversight. It's housed within the Home Office, but it does provide independent oversight in its functions of the use of biometric data and its exchange with different member states within the EU. There are other functions as well in terms of the advice and guidance that that office gives, particularly with regard to surveillance cameras. There's a surveillance camera code of practice that currently is issued by that office. Another very significant legal element that the court examined very closely in the South Bridges case. That entire office and that entire code of practice would be abolished. But these duties that are being added to the remit of our Data Protection Authority is an attempt to incorporate some of those responsibilities and oversight functions within the ICO. But why is this problematic? This is problematic because the Information Commissioner's Office has a very different remit and focus. So there are serious concerns that this is undermining the independence of the office, its resources, but also its capacity to be given these additional oversight functions which operate in a very different supervisory context. So why are these changes problematic overall in unison? Well, they place limits on the existing rights and safeguards that we currently have under the Data Protection Act of 2018. And this is at a time when law enforcement use of data-driven systems, as Elena just mentioned, AI-based systems, other emerging technologies, are only on the increase. Systems like live facial recognition, emotion monitoring, systems that are classified very categorically as high risk under the EU AI Act. So arguably, what is needed is more robust oversight and independent monitoring of these systems, certainly not less. And another amendment in terms of the Information Commissioner's Office is that the Data Protection Authority itself would no longer exist. It would be replaced by an Information Commission. The existing Data Protection Authority would just be a chair of that commission. It would also be made up of non-independent members, executive members appointed by government, appointed by the Secretary of State. So these are very clear encroachments on the independent functions and operation of the Data Protection Authority. And these are issues that have also been highlighted as well in terms of implications for the UK's adequacy decisions under both the GDPR and the Law Enforcement Directive. And these are very live issues because there are sunset clauses for both of those adequacy decisions, and they expire in about a year's time. And there is very close scrutiny at the moment of these reforms in the UK. The House of Lords is finalising a report on this, its European Affairs Committee, and it received some very robust evidence from the European Parliament's Justice Committee, the Libby Committee, specifically making criticism of the encroachments on the independence of the Information Commissioner's Office and other criticisms. So I will conclude there because I have gone slightly above my time. But for further details, I hope we can explore this more in the Q&A. I also had the wonderful privilege to contribute a chapter on Brexit in this fantastic commentary. And if that is not enough, there is more evidence that was presented to the House of Lords by myself and other experts in the past few weeks on the Law Enforcement Directive. Thank you.
Thank you very much, Nora. This was super important, and I think it's quite worrying how the UK is shifting away a bit from the EU principles. So I will immediately open up the question. I think we heard for the public. Yeah, I know we have 10 minutes already.
14.
So 14 minutes, not 10. Okay, we have 14 minutes for questions. So please, maybe the first one. Do we have a microphone?
Yeah,
Yes.
there.
Okay, then yes.
We have a question
We
here.
have a question here, but you can start here then and come back. Yeah, please start and then.
Hello.
Yeah.
It's on. Hi, I'm a DPO of a federal government institution in scientific research. So actually what we do, we get samples from police agencies and then we analyze them and then we give them back to a magistrate. So it's always on a claim for magistrates. But the problem, as Mr. Roeks mentioned, in Belgium, in all member states actually, the authorities under the LED are defined in national law, and our institution is not in that Belgian law, which is one of many flaws I fear in the Belgian national law, but anyway. And so the problem we have is that actually we get data that is under the LED, then with us it's under the GDPR, and then it goes back under the application of the LED. So my question was, do you have any experience or knowledge of other member states who have the same conflict, or any advice on how to deal with that? Thank you.
Thank you. Maybe we collect one more question. And can you briefly say to whom the question goes? To everyone or to?
Yeah, who wants? Who can
Thank
help
you.
me? That would be fine.
Thank you. So maybe we collect one more question, and then, because otherwise. Andra, yes.
Andra had a
please.
question.
Can you give it?
Here,
Yes.
we need the microphone here in
Yes,
front.
in front. Sorry.
Andra.
Andra, can you turn? Yes.
Thank you very much. First of all, great panel. I'm very happy about all your contributions. They've been very complex, in-depth, and I can only support the commentary. I have it, I use it. I've been lost without it for some time, so I'm really, really happy that it exists. You've managed to formulate complex questions very clearly, and I will try to do it to the best of my abilities as well. I have a question as regards the lawfulness of the processing, because you mentioned, we know in the public sector, specifically, you have the processing needs to be necessary for the performance of a task and by a competent authority for one of the purposes in Article 1, but it also has to be based on union or member state law. And now, because we are in the context of AI and artificial intelligence, we have Article 11 that says fully automated decisions are prohibited unless they are authorized by member state law or union law. And I was wondering, because I've seen this, I have this tendency, the impression, I'm under the impression it was argued that a lot we can use artificial intelligence system because they're necessary and so on. But if I look at the LED, it tells me it has to have a basis in union or member state law. Now I'm asking, do you know of national laws or union laws that actually are specific enough? Or can you comment on the quality of this law? How specific does the law need to be? You mentioned purposes and that they need to be specific. Or otherwise, if you know of situations in which, in the practice, we try to avoid fully automated decisions so as not to fall under these prohibitions, and then what measures would be considered adequate so the decision is not fully automated? It speaks to the quality of the human intervention, of the human in the loop. Thank you.
Thank you. Maybe we start with first. Yeah, there's a third one, but maybe we start answering. Does it relate to that? Yeah. Okay. So, please, and then we start answer.
Only one thing about adequacy decision. You have with UK has adequacy decision, but moreover, how about the Japan want to, or I don't know actually the situation in my country, Japan. But do you have some information about adequacy decision with other countries? This is my question.
Okay. So maybe we start answering the first question first. Is anyone here to answer or likes to add something to the first question? Yeah, Ruben, please.
Sure. The question raised with regard to the interplay between the LED and the GDPR in practice, this is an extremely hard topic. I can only tell you what I've seen in practice that they try to do across the member states in order to resolve the issue. And I'm not saying that I agree with its legality, but it is what it is. We've seen that whenever the law enforcement agency sends something through to an entity which falls under the GDPR and it has to come back, is that they try to come up with their own legal basis, and that typically takes the form of a memorandum of understanding. We will, as law enforcement agency, conclude a memorandum of understanding with entity X, Y, or Z, and that will sort of extend the powers that we have to a mandated entity which we mandate ourselves. can it be construed as a legal basis in the sense of the, well, either the LED or the GDPR? I doubt it, but it's the way they do it right now. That's the only insight that I can offer. It's done on a very wide scale, and I have the impression that there are not many alternatives to that mechanism. The whole protocol thing that we know in Belgium doesn't work in this space. So, yeah, for the moment, that's what they do. Invent your own legal basis.
Not that motivating, but yes, Uri will clarify this in a moment.
Yeah, well, from my own perspective, I don't see such a big problem here because, well, first of all, the question is whether it's good to define who are the competent authorities under the LED in national law or not. There are obviously some advantages of that for legal certainty purposes, but also the scope of the GDPR and the LED are defined in the GDPR and the LED, so you cannot choose whether you want to apply the LED or you want to apply the GDPR. So that's already a problem when national legislator starts picking and choosing certain authorities to be competent authorities. But again, we have, what Herke said, we have this very fresh, fortunately only obiter dictum in the Hadopi case, so I hope this can be clarified, refined, if not rectified in the future case law, because this opens the door for a lot of authorities to claim that they are competent authorities under the LED. But going back to the main question of like data flowing from LED to the GDPR and back, there are provisions on that. Paragraphs 1 and 2 of Article 9 of LED are so-called launchpad provisions. So how do you launch the data out of the LED realm into the GDPR realm, and how they come back? That I think I already explained in my interventions. Of course, there is also a question of whether you are acting as a data processor for the law enforcement authority or not, which also feeds into the answering of that question. But I would just advocate against broadening the scope of the LED, because, of course, that's not only detrimental to the FA util of the LED, but also at the same time at the GDPR. So if you are broadening the scope of the LED, you are shrinking the scope of the GDPR, and we should not do it overly to the excessive extent, covering authorities that are not actually law enforcement authorities, just because it's more convenient to apply the LED for some reason.
Okay, thank you. I hope it helps a bit. Now we come to Andra's question on AI automated decisions. Do we have any answer or maybe ideas on that? Anyone?
Oh, very quickly, I would say that there is one quite clear new framework about to be published in the official journal any day now. So we have the EU AI Act, and that doesn't necessarily cover every particular type of AI-based system, but it would definitely have application to the specified AI systems that you have under, say, what is currently Article 5 of the draft EU AI Act. So you have, various systems relating to remote biometric monitoring in public spaces and emotion monitoring, for instance. So they are specified under the AI Act, and there is a requirement under the AI Act that member states implement domestic legislation to include all the relevant safeguards and provisions that would govern the use of those particular systems. The Law Enforcement Directive as well, as you will see in the commentary, and as I'm sure you know, as a directive will be transposed by member states differently in terms of the legal basis that they use. And then just very finally, when it comes to the point of what constitutes a legal basis or legislation, as Ruben and Uri just mentioned, it's a very vexed question, actually, because it's not one that the Court of Justice has engaged with in very comprehensively. The focus is much more on its proportionality assessments, much less on legality. But when it has talked briefly on what is in accordance with law, the Court of Justice has made the brief statement that, well, there should be legislation and the safeguards should be within that relevant piece of legislation. This is very far-reaching because the European Court of Human Rights has a much, much broader scope as to what it considers to constitute a lawful basis in domestic law. It's so broad, it could very much encompass the memorandum of understanding that Ruben suggested, for instance. So that's an ongoing, very vexed question where more guidance from the Court of Justice would be very welcome. And just a very quick follow-up to your question, there is only one law enforcement data adequacy decision that's been issued, and that's to the UK. And it's likely probably to only be the only ever one because the UK was a former member of the EU, so.
Yeah, but adequate decisions are within the remit of my part of the European Commission, so I have to say that there needs to be also an appetite of a third country to have an adequacy decision. In the case of Japan, the appetite was with the GDPR. It wasn't there for the LED, so you have to take that into account as well.
Okay, thank you very much. I would really give a last word. No, do you think we can?
If there is another question,
is there another
then I'll
question,
give
a
the floor
final
to the
question, but
question.
otherwise, I think it's we covered a lot of things.
I
think
think
I would.
I just want to just respond. I think we
Yeah.
didn't satisfy you with the answer,
Yes.
and I understood your point. So I just wanted to say that I think it is super complicated, and I don't have an answer to that. I'm just curious to see actually how law enforcement authorities are going to try to implement these two instruments in a creative way. We have seen they are being very creative in trying to keep obligations away from them. So I'm a little bit less optimistic. I mean, maybe because I have read this thing twice in detail and I've seen all the flaws already there. Putting AI Act on top will be quite complex. Plus, I was not very happy with the fact that we have so many exceptions in the final version of the AI Act. I mean, if somebody looks carefully what they cover, is huge.
Yes. I think it's maybe not that optimistic final word, but we are very glad that you have been here at this early time in the morning. We thank you very much for your attention, and yes, good conference again, and good safe trip home.
So
Thank
I
you,
would
Elaine.
also like to thank, because as TILT we organized that panel, I would like to thank Francisco for accepting to do the moderation, and all the speakers for being excellent speakers, perfectly prepared, and having this lovely panel. So thank you very much.
Thank you.
And if you want to buy this, there is